Number 46, Connaughton versus Chipotle Mexican Grill. Counsel?
Thank you, Your Honors. Good afternoon. May it please the Court, my name is Dan Kaiser. I represent the plaintiff appellant, Kyle Connaughton, in this appeal. Mr. Connaughton.
Counsel, may I interrupt for a moment?
Sure.
Would you like some rebuttal time?
Yeah, 2 minutes, Your Honor, if
Certainly.
I may. Mr. Connaughton
Counsel, what are the damages that are either expressly set out in the complaint or inferable from the complaint?
There are, in the nature of reliance damages, which are the only category of damages that you can get here or in any fraud claim, this is a fraudulent inducement claim, there will be two principal categories within that larger category of reliance damages, Your Honor. There is the lost business opportunities that he forewent when he relied upon the concealment. In this case, fraudulent concealment is the nature of the fraud, and went to work for Chipotle. That lost business opportunity was addressed by the First Department's majority decision, and in that decision, the majority said, and actually the dissent on this narrow part of the decision agreed, that lost business opportunity is not in the nature of the kind of damages you could get in a fraud claim. But I think what the court did, Your Honor, is they confused expectation damages with reliance damages. You can have a lost business opportunity damage that is in the nature of a reliance injury, or you could have a lost business opportunity that is in the nature of an expectation loss.
These damages specifically pled, though, as to what business opportunity was lost?
It was, Your Honor. In the complaint, there is reference in the complaint to two other restaurant organizations that he was dealing with at the same time he was dealing with the Chipotle organization. And he testifies that they were well underway, those discussions, and then he forewent those discussions in order to take the Chipotle opportunity.
But isn't it still speculative? He doesn't know if he'd actually have ever gotten their interest.
Well, to that, Your Honor, I would say there is one. I would say no, it wasn't. I think that if you permitted this case to proceed, I think what the discovery would demonstrate is, in fact, that those business opportunities were real, that they would have come to fruition, and he would have been able to pursue them. But
And how
at
would
the
you
point,
measure the damages, though? That's
well, if it's a business opportunity, Your Honor, if that's what we're talking about, then the measure of damages is if, in fact, he turned away from those opportunities and went because of this fraud.
It's the transition from speculative to real, I guess, is what we're looking at here. Right. It's hard for me to identify in the complaint that moment where it actually moves from speculative to real.
But I would say, Your Honor,
well, let me just say
this. I'm sorry.
So it's no problem. If there's a place that you want us to look, say, here's where it does that, Judge. Tell me where that is. Where does it transition from speculative to real?
Well, I think my answer to that, respectfully, Your Honor, would be that the transition would be in the information that would be developed in a factual record that is not before this court. So then the question is...
So your answer is it's a motion to dismiss, Judge?
It's a motion to dismiss, right. And that at the point of a pleading, does this plaintiff have to provide those kinds of particulars that would permit a court, any court, to answer the question as to whether it's speculative?
But I guess the question is unlike, for example, a situation where a person goes from a particular job and then goes to another opportunity and has that lost opportunity, there's something that they can measure what they would have had they not moved to this new venture. Here, what could he possibly tell, the jurors or the court that would make it a non-speculative damage award?
What he could tell the court or a jury, Your Honor, one day is that I think the name of one of the entities was Maverick Restaurant Group or something to that effect, that look at, for example, this testimony from Maverick, who says, sure, we love the ramen noodle concept. We were prepared to make a deal with this with Mr. Connaughton, this world-renowned chef, but then he came to us and said he was going the way of Chipotle. That
But
is
even
a
if they said
tangible
that,
injury.
but even if they said that, in this case, one of the defendants, Els, the CEO, comes forward with an offer and they negotiate. So even if they said that, you got to have a negotiation. There's still no certainty that there ever is going to be an agreement that's consummated. A mere interest in the idea, the concept, sounds to me still speculative.
Well, we don't know, Your Honor, because we didn't develop a factual record, so we don't know how far down the road of consummation, as you put it, they were.
Well, your client knows enough to put something in the amended complaint, right? Other than I had a bunch of designs and I had a concept
Sure.
and I was shopping it around.
He may have known that, Your Honor, but then the question is, at the point of a pleading, a notice pleading, did he have to plead that? There's all sorts of, for example, strategic reasons. As his lawyer, I may not want to put that in a pleading if I'm operating under the assumption that this is a notice pleading, that there's no particularity requirement at the point of a complaint to set forth all of the information that would go to whether or not these damages are speculative or not.
So is there any other category of damages or another type of damage other than lost business opportunities?
Well, as the dissent did note, which I think is also in the nature of reliance damages, would be damages to his, and was pled, certainly consistent with notice pleading requirements, is damages to his reputation, his professional reputation. He went, he lives in his profession in a rarefied space in terms
Is
of
that
being a
based
chef.
on what might have happened if they had gone forward to it?
Well, I think both, Your Honor. I think that there is, and the dissent noted this as well, is that he may well have already, at the point of his departure from Chipotle, have already suffered reputational loss for having worked someplace that was destined to fail from the beginning, that here he is, this really very reputable guy, going to introduce this concept of ramen cuisine to Chipotle, works 2 years there in this relatively small industry, and suddenly is left without having accomplished that task, and in this small industry, people understanding potentially, and that ultimately came out, that the David Chang, also very well-known chef, was doing this for Chipotle under a non-disclosure agreement. So here he is effectively having, certainly the perception of having stolen this idea and worked on it. I mean, there is significant reputational loss that is potentially...
Counsel, I find what you just said very interesting because your
I'm sorry,
client... I know, it's
I
weird.
heard a voice.
It's kind of weird, right? Ghost voice. I find that interesting because your client is also, as you pointed out, a very well-known chef, and he apparently didn't know that Els was working with Chang and Momofuku on this.
He did.
So how,
But then it came out, and so at some point, and there's been...
No, but it came out to him, not publicly.
Yeah.
I think that's the point.
Well, then, but, I mean, certainly not in the record and pleadings, but certainly then there's been, in his world and beyond, a fair amount of press on this issue about this
He
dispute.
filed a complaint, so now you've got...
Well, but, you know, there is...
And he hasn't presented himself in a bad light in the complaint. He certainly presented Els and Chipotle in a bad light
No, he
in the
didn't present
complaint.
himself, that's true, Your Honor,
That's
but...
true. He
but if
presents
you're-
himself as someone who
But
didn't
there
know
is-
and was duped.
Right, but having worked, for having worked as long as he did there on this concept that someone else was doing...
But if he's an at-will...
And there's perspective
Yes, I
loss.
understand, but he's an at-will employee.
Yeah.
So let's say this wasn't the problem. Els just woke up one morning and said, you know what, I've decided I don't want to do this after all. I've decided it's not a good idea. You're fired. You're fired.
No, then, well, he's an employee at will, and certainly
Right.
he has the right to
Correct.
do that, and we don't challenge in this lawsuit his right to do that, and we don't
So
certainly...
what all I'm saying is the fact that they never launched the restaurant in and of itself is not necessarily a
No, it's
reputational
not.
hit because he's
Yes.
an at-will employee,
with
and he could have
that.
been fired at any time.
I agree with that, Your Honor.
And he could have left at any time.
I agree with that, Your Honor. It's not the failure to launch the restaurant that is the consequence for him and his damages, but having worked, and it's not just the reputational loss we would argue there, and again, there's no record here to know what his reputational loss is, it's just pled. There is, as the dissent also, I think, rightly noted, there's the prospective reputational loss going forward, having clashed in this way with another well-known chef, perhaps being, accused of stealing his ideas, which, by the way, inevitably would have occurred had he continued down this road. I mean, David Chang wasn't going to sit idly by and permit this to occur. So I would say just two things on this. There was reputational loss, but again, this is at the pleading stage. So to plead the reputational loss without, then having the opportunity to say, through discovery and all the ways in which plaintiffs, litigants prove damages, it's premature to say at the pleading stage, it's speculative, or premature to say we haven't had an opportunity to litigate these issues.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon,
Good afternoon.
Mr. Kaiser. May it please the court. In terms of reputational damages, if my reputation is damaged in the legal community, I know it's damaged. I hear that in the courthouse. I hear it.
Yes, but how specifically do you have to plead it in a complaint?
But I would at least know it was damaged, so I could say my reputation has been damaged because of this. My reputation. It is only notice pleading, but if you look at his complaint, all the complaint says is would, coulds, shoulds. There's no definitive. I certainly know when my reputation is damaged because it's
Isn't
damaged.
inferable from the complaint, he's shopping this around, he ends up in this agreement with Chipotle, they all know he's doing this, he's in various press releases, his name is associated with Chipotle, and then he leaves, or he's fired, he's gone. Isn't that a hit to his reputation?
Not unless it's, well, not necessarily. He could, as Your Honor just pointed out earlier, he could have left for all sorts of reasons. He could have quit. He could have got fired. Mr. Ellis could have woken up one day and said,
But isn't that the point? It's showing there's some weakness in the concept, or there's a weakness in him. Otherwise, if it's such a great concept, it's such a great partnership as it has gone on for over 18 months, they would have seen this to fruition.
But that comes with every time an employment relationship ends. If I leave my old firm, there could be rumors swirling around, there could be discussions about why I left, but that's not damage to my reputation that I can articulate in a pleading and get past the pleading stage before this court.
So, counsel, if he'd pleaded that his reputation was, in fact, hurt, that would be sufficient for you?
I think if he could articulate how it was hurt and why it was hurt, might be sufficient.
In the complaint?
In the complaint, but he can't articulate that. And he says my reputation was damaged. The one person who knows if it's damaged is the person who's pleading it. And he can't say that. And now if we look at the other allegations he talks about loss of business opportunity. Loss of business opportunity in and of itself is not damages that are recoverable here in the state of New York. I mean, this court's already ruled on it in the Smalley versus Dreyfus case. That was the case involving a number of young employees that were seeking employment at the Dreyfus Fund, and they were told repeatedly that this company's not going to be sold, we're not going to be merged. That went on for 4 years. And then when the company was sold, they were all fired, and they said, hey, well, hey, we lost
But
this.
isn't that different from the damages that are being asserted here, where they're not saying because it didn't pan out over here, but because I could have done something else. I had other opportunities that were concrete opportunities. I haven't told you what all the details of them are, but why shouldn't they be able to show that?
Because, well, those are not recoverable damages in New York State.
Well,
Anytime you, I think
what
the
about Stewart versus Jackson and Nash, the Second Circuit case?
that's the case with the young lawyer, I recall. And in that case, we had an affirmative, present misrepresentation. At the time they hired that young lawyer, that law firm never had an environmental practice to speak of at all.
Right. Well, here we're talking about an omission.
Okay,
right?
but so let's use that. Let's use that case. In our case over here, Chipotle was in a position to pursue a ramen concept. They were in fact pursuing the concept. When they hired Mr. Connaughton, they said, "Go explore this concept."
But you agree that under certain circumstances, an omission can also constitute a fraudulent.
It can under certain circumstances. We don't think those circumstances are here.
But let's just assume that they were, because right now we're talking about damages. So if those circumstances were present, and there was a fraudulent omission that induced Mr. Connaughton to forego other business opportunities, why can't he recover for those business opportunities if he can prove them?
Aside from the fact that he's an employee at will?
Yes.
Okay. I mean, he's an employee at will, so we don't even think we get there. And even if he could pursue them, he hasn't articulated them, and he doesn't seem to have any of them, because if he had them, he's in the best position to plead those. And the mere fact that he gave up another opportunity is not in and of itself sufficient. People give up opportunities every day. I leave one firm to join another firm. I give up opportunities. I turn down one case to take another case. We all give up opportunities, but we sell our time, we receive our compensation for it, and in doing that, we may have given up another opportunity. And that's what we have over here.
Haven't we already decided, though, counsel, that you can pursue a fraudulent inducement claim even if you are an employee at will? In Smalley, didn't we decide that?
You did not, in the Smalley case, that's true. They could pursue it if they established damages.
That it was different than just being terminated.
Well, that's right. But in the Smalley case, if anyone ever had damages, those guys had damages because they gave up numerous opportunities to work for Dreyfus. And they were misled. They were misled concerning Dreyfus's plans for a merger or a sale of the company. I don't remember the details on that. But in that particular case, that was not sufficient because the court said, this court said, any people issue opportunities all the time. They choose every day to take one opportunity over another opportunity, and just because you forego.
The question is are you induced to pursue that opportunity by some fraudulent means? That's what the difference is, and why, and whether you can recover under those circumstances, not just any circumstance where you choose among a variety of options, and you know what there is to know.
I think what the opinions have said, they say if you are induced to pursue something under fraud, that's one aspect of it, but you don't get any further unless you have damages. And in this case, there just simply aren't any damages. Putting aside the question as to what the circumstances were.
Seems like we're going in a circle here.
We may very well be. We're going back to damages because we don't believe Chipotle or Mr. Ellis was fraudulently induced anyone to do anything. But
if he was, and if he could prove that he was damaged, the question is, should he have an opportunity?
Well, Your Honor, those are a lot of ifs. I mean, if he could prove that, and if he could prove that, well, certainly then. But in this instance, there are no damages alleged. They're just simply not there. This court's been very consistent throughout the years. You got to have an out-of-pocket loss, and nominal damages just don't do it. And in this case, the pleadings all reflect.
Can you infer that he put money into the negotiations to enter the agreement, or to solicit the business of L's? Are those damages that he could get?
I think the court allows that you could establish inferred damages or an inference of damages. But when you look at the cases that discuss inference of damages, you know, those cases, the damages sort of smack you right in the face. We're talking about the Black versus Chittenden case. That's the bowling alley case. A guy goes off and he buys a bowling alley, and the bowling alley doesn't work. You know, there's something wrong with the alley itself. That's a very simple, clear, obvious inference of damages. So what did he put into this? Well, we know he hired a lawyer to negotiate it. That's not an inference of damage, and quite frankly, Your Honor, that cuts against him because he goes in with eyes wide open. He hired his own counsel to negotiate this deal and to assist him as to whether or not he should make this decision.
But he puts in money and time and effort to producing a concept that's specific to Chipotle after L's reaches out to him and says, yes, I have an interest.
But he was getting paid for that. So
He was paid, I'm sorry, he's paid before he enters the agreement?
Well,
Is that
people
what
do
you're
it
saying?
all the time.
No, I'm asking you.
No,
You're saying
no.
he's paid before he entered the
No.
agreement? I don't remember that from the
No, he
amendment.
wasn't paid before he entered the agreement, but people invest time and energy in all sorts of things.
No, but I'm asking you about what might be inferred from the complaint. I'm just asking you, can't you infer that from the complaint?
I don't think you can infer that.
Why not?
Because that's something that everyone does. Everyone puts time and effort into something that they go off and sell. Then they go
You're
off.
saying because he would have had to do that
He
with
had to do that
anyone
with
else?
anyone else.
So he can't get reimbursed or he can't get damages for having put whatever money it took?
No, Your Honor, because.
Excuse me.
Okay.
To provide the kind of plan that was designed specific to Chipotle?
No, I don't think so.
Chipotle?
I don't think so, Your Honor, because all that effort is entirely subsumed in everything he's always going to do. He always does that.
Because he was shopping around.
It-
Because
it
this
was
is
in
the
the price.
process he was going to.
It was in the price.
It's
So
not
he's-
unique to your client, is that what you mean?
I think that's one answer, but I also think the better, or the different answer is that it's all entirely subsumed in it. So when he was paid for his services, he negotiated his salary, he negotiated terms with Mr.
Isn't that agreement for him joining and then,
But that's right.
working on the launch?
That's right, but when he negotiated that price, presumably he considered the time and effort he put into developing the concept.
Why are you going to presume that?
Because
Why can't you infer it the other way? It's a motion to dismiss,
you-
it's just on the complaint.
you theoretically could, but I think the law suggests, I think logic tells you, when parties negotiate a price, there's a meeting of the minds as to the price, and it includes those efforts that you put into the project as you go off and sell it.
I want to go back to one thing that you responded to Judge Stein when she asked you hypothetically, assume that he was fraudulently induced, and you referred to the fact that he's an at-will employee. If his allegation is he would never have signed the agreement in the first place, why can you rely on the fact that the agreement says he's at will?
Because, Your Honor, he's always an at-will employee.
He was induced to enter into the agreement by fraud.
But that doesn't change anything, and we don't agree that he was induced to enter into any agreement.
Well, I understand you don't agree.
Yeah. We just simply don't agree that. And even if there was some sort of inducement in it, I think the law is still pretty straightforward in this state that these are at-will employees. And absent some special obligation or duty on behalf of Mr. Els, there was no obligation to share any information.
Thank you, counsel. Mr. Kaiser?
Just very quickly, Your Honor.
Yes.
Counsel made the point that it was an employee at will, and if you leave a job, any of us who are in jobs and leave, we could suffer reputational loss, and that's the nature of employment. You go from one place to another, people could, that may be true, and we may suffer damages in leaving an employment at will, but the question here is there a carve-out here from that employment at will doctrine because of the fraud alleged? So if in fact there is fraud, and if in fact it's demonstrated, then in this case, under these circumstances, it would be a category of damages where it wouldn't otherwise be recoverable damages if it was just an employment at will situation. And as far as I just wanted to very quickly talk about.
Do you agree, counsel, even if this is a fraudulently induced employment, that he could bring that claim as long as he does have some damages, even if he is an employee at will?
Yes, he can bring the claim if he has some damages, which we think he has here, which leads me to my last very quick point, which is counsel had discussions about what the damages were, and Your Honor was asking what can you infer those out-of-pocket expenses, and he did, as he mentions, he had an attorney, he did lots of things, he specifically tailored this to Chipotle. So there are damages there, but all of this we're talking about without a record as to what those damages are. Certainly from a notice pleadings standard, I mean, we will see if this should go forward as to exactly what the nature of those damages are, including some of those out-of-pocket expenses that were tailored to Chipotle to offer this up to Chipotle.
So you're arguing that's another class
Another
of
class,
damages?
yes, that's another.
What he put into it to indeed get Els to offer him.
And also, by the way, what he put into some of the other specialized service platforms that he offered to some of these other alternative business opportunities that he then had to walk away from.
Post Els reaching out to him?
Well,
Pre-Els, he's doing that anyway.
Well, he's doing that anyway, but then he's walking away from that, right, because of the reliance on the omission.
But are you saying that all a plaintiff has to do is say, I have been damaged, period?
But he doesn't say that here, no, Your Honor.
Okay.
But what he says here, I would say the notice pleadings require something more than that.
How much more? Tell us what there is more that gets us over that.
Specifically
For fraud.
here, he identified.
For fraud.
For fraud. Specifically here, he by name identified these other business opportunities in the pleadings and talked about the progress of those discussions that he then walked away from to
You see what the
pursue
problem
Chipotle.
is, though? It's the actual nature of the damages rather than the identification of possible damages in the context of a tort. We're always talking actual damages, and it's hard for me to identify those. That's why.
Well, the actual damages that are pled, meaning, and when I say actual,
Actual, I mean calculable.
calculable damages are the lost business opportunities that are calculable once you have a record to calculate them, but they are clearly pled in the pleadings, and reputation loss, which is pled. Now, more than that, we would contend would be, you would be moving from a notice pleading standard on damages to a more particularized pleading standard, which we do not believe would be consistent with New York State law generally on pleading damages beyond, in the context of a fraudulent inducement.
So your position is these other business opportunities, going to do discovery, and someone from any of these entities is going to say, yes, we were ready and definitely going to enter an agreement, regardless of the terms?
Well, these entities could come and say, yeah, sure, we had.
So if the discovery proved that they said, well, we weren't sure, we liked it, we need to talk to him more. Is that enough?
And if we're back before a court on a summary judgment motion.
No, I understand that.
Then maybe he doesn't prove those damages. But it's beyond the scope of this proceeding. But yes, I think it's certainly a provable category of damages. Whether he proves it or not is for another day.
Thank you, counsel.
Thank you. Thank you, Your Honor.